Superior Court is the court most commonly depicted in crime dramas on television. It is the highest trial court in Washington state. Superior Court deals with the most serious of crimes, known as felonies, which carry punishments of over a year and up to life in prison. In addition, Superior Court hears all high-dollar civil litigation, lawsuits over $100,000.
Superior Court is considered a court of general jurisdiction. That means that virtually any type of case could be filed in Superior Court, and you'll see sometimes in a criminal case, cases that would otherwise be brought in District Court will be added to other cases in Superior Court. But the cases that can only be brought in Superior Court would be serious criminal charges, so felony charges for criminal cases, family law cases, cases involving title or possession of real property, probate and trust cases, and then disputes over $100,000. Those are sort of the cases that can only be brought in Superior Court and couldn't be brought in a lower trial court or a court of limited jurisdiction. In addition, Superior Court also hears appeals from those courts of limited jurisdiction. So if someone has a case in District Court and disagrees with that determination, their appeal, their right of appeal, is to Superior Court, whereas when someone disagrees with a decision I make in Superior Court, they have a right of appeal to the Court of Appeals.
If you watch a legal drama on television, you will most likely see the judge on the bench presiding over a trial. Most often, there's also a jury. But there are many steps that take place in Superior Court before the trial even begins.
Let's kind of start with how a criminal case might start. So it might start with an arrest or with a summons. A person comes to court and they have a probable cause hearing. That's where a judicial officer tries to figure out if there was a reasonable basis for the arrest or for starting the case. At that hearing, then the judge is going to set the conditions of release, maybe set bail. The next hearing out is the arraignment hearing, where a person faces their formal charges. And then after that arraignment hearing, there might be an omnibus or a couple other hearings along the way before trial, just to see how the case is progressing and making sure that people are staying on track and taking account of speedy trial, your right to have a trial in a short time frame. And then you get to trial. So that's kind of the life of a criminal case.
There is a lot of complexity in Superior Court cases, and the judges work to ensure that justice is being delivered fairly.
Are both sides given enough time to respond? Has the other side gotten even notice of this hearing? So procedural justice is how we got here, how we're making the decisions. And then we have substantive justice. And to me, that's getting really to the heart of the issues. Like, is the law being applied fairly? Are we doing what's right? Are we looking at all of the equities that are involved in this case? Are we applying the law equally? So no matter who is involved, we're applying the law the same for everybody.
We have 3 equal branches of government, and the judicial branch must apply the law as it is written by the legislature. Laws are a product of a specific time in history, and therefore they can change over time. The Sentencing Reform Act, passed over 40 years ago, set up the current framework for sentencing at the Superior Court level. And although it has been amended many times over the past 4 decades, the overall idea of the act remains.
The Sentencing Reform Act that was passed in the 80s, I believe in 1981, created a very fundamental change in how judges sentence people convicted of crimes, in particular felony crimes. The Sentencing Reform Act only applies to felony crimes. But it was a huge change by the legislature in changing and, frankly, reducing the discretion of the courts. So previously, judges had broader discretion in how to sentence someone, and so there were what were called indeterminate sentences. Under the Sentencing Reform Act, there are determinate sentences, which means for every individual crime, there is a schedule or sort of a chart in terms of what the appropriate sentences are.
It gives a range for sentencing depending on the seriousness of the crime and what the defendant's prior history has been. So somebody who has had no prior history is going to get a shorter sentence for the same crime than somebody who's had a longer history. And within that framework, there's a range, and then my discretion would be to act within that range or to take into account extenuating circumstances if I'm going to go outside of the range.
So the idea was that judges should be more accountable to the public, but that also this way people had clear expectations and there was more uniformity in the decisions that judges were making in sentencing. I think it was recognizing that previously there could be a lot of disparity depending on the individual judge you would appear before, And those sentencing decisions were really informed more about the individual judge's history, their own philosophy about sentencing and criminalizing behavior. And of course, it could be informed by their own unconscious or conscious biases. And so it was this idea that it was much more fair to have these clear expectations and more uniform results. I think there, like everything, are also some unintended consequences of that, because sometimes the most fair thing is not necessarily to treat people the same if there are reasons to treat people differently, whether it's because of specific trauma that someone's experienced that might impact them committing criminal behavior or other individual circumstances. But under the current scheme, those types of individual circumstances are not considered.
We are trying to figure out what the legal issues are. What is the law that applies to the case? And how are we making sure that we're applying it equally? So checking your own personal biases. Like you might see something or see somebody and say, oh, this is how they are. And then just thinking, no, wait a minute, let's look at what the real issue is here. What does the law tell me is the outcome for this? The court system is just this really elaborate but fundamentally human way of trying to resolve questions and disputes.